Welcome everybody to the first of two sessions, which are organised by Temple's International Committee on Advocacy before the International Criminal Tribunals. The IN is an institution that has been training lawyers for 600 years, and Temple barristers, and the IN itself has performed an integral role in the development of international justice from the London Conference of 1945, which was the precursor to the Nuremberg proceedings, through to the international criminal courts and tribunals of today. So today we begin our session with on advocacy before international criminal courts and tribunals, and we're delighted to welcome a distinguished panel of both senior prosecutors and some of the most experienced defense lawyers in the business, with experience spanning all of the tribunals and several of the most landmark cases in international criminal law since Nuremberg itself. The session will be moderated by Stephen K. QC, who is head of chambers at 9BR Chambers and is arguably one of the most experienced defense practitioners in the world of international criminal law. As counsel in the foundational Tadic case, the Masema case at the Rwanda Tribunal, for Slobodan Milosevic at the International Criminal Tribunal for the former Yugoslavia, and before obtaining acquittals for Ivan Cermak at the Yugoslavia Tribunal and President Uhuru Kenyatta at the International Criminal Court. Stephen and his team at 9 Bedford Row, of which I'm part, currently advise governments, individuals and civil society on all aspects of international criminal and complex criminal law. After Stephen, we'll hear from James Stewart. James was elected Deputy Prosecutor of the International Criminal Court in 2012, and he served in that capacity until last year. Prior to joining the ICC's Office of the Prosecutor, James worked as General Counsel in the Crown Law Office within the Ministry of the Attorney General in Toronto. He then served as a senior trial lawyer at the Office of the Prosecutor at the Rwanda Tribunal, as Chief of Prosecutions at the Yugoslavia Tribunal, and as Senior Appeals Counsel and Chief of the Appeals and Legal Advisory Division at the Rwanda Tribunal. James will talk about appellate advocacy with a specific focus on appellate advocacy before the International Criminal Court. Kirsty Sutherland is a rising star of the International Criminal Bar and has acted as co-counsel at both the International Criminal Court in the case of Al Hassan and at the Khmer Rouge Tribunal in case 004. Kirsty was an integral part of Stephen's team defending Uhuru Kenyatta, and she's a visiting fellow of practice with the Oxford University's International Institute for Ethics, Law and Armed Conflict. Kirsty will focus on current trends at the ICC, interlocutory applications and questions of evidence. Finally, we'll hear from Andrew Cayley at UC. Andrew is the former Chief International Co-Prosecutor at the Khmer Rouge Tribunal. In that capacity, he prosecuted the senior leadership case at the Khmer Rouge Tribunal in a case which alleged what was arguably the most serious criminal conduct charged on any criminal law indictment since Nuremberg. Prior to prosecuting in Cambodia, Andrew defended Charles Taylor, former president of Liberia, at the Special Court for Sierra Leone, and he's also part of Stephen's team defending Ivan Cermak at the ICTY. Andrew will speak about the role of the international prosecutor and the power of the opening speech. So without further ado, Stephen will begin with a video. Unlike English criminal proceedings or English court proceedings, international criminal proceedings are televised, which in addition to bringing heightened transparency and public access to the proceedings, also provides us with a great training opportunity. So we'll begin with Stephen's cross-examination of Renaud Toynens, the prosecution's military expert in the Cermak case. Over to you, Steve.
Thank you, Josh. So we're going to open the sort of introductory session now and play this tape as an example of cross-examination in an international Criminal Tribunal, and you'll notice certain differences from the normal style in English courts. Could you play it, please? Thank you. All those orders already and know what you refer to, but you told us you're an expert on command and control. And the question I have is this. If all this is happening and all these orders are being issued, it doesn't seem that the man you described as being the superior military authority is within the command and control system. Isn't that right?
Yes, and that is why I have included this section on the nature of the professional relations between the commander of the split military district and commander of the Canadian garrison, starting on page 258 of the second part of the report. Even independently of the position of General Cermak as what I described as the most senior military authority in CNIM, even as a garrison commander at a much lower military rank than the rank of Colonel General, one would expect that, at least in accordance with the doctrine, he, as the garrison commander, would have been included in orders that deal with the relocation of units to barracks in the zone of the Canadian garrison.
In fact, in relation to all these units, you couldn't have effective command if you're outside the system, if the system is not working with you in it as a component commander, could you?
That is correct, but I have not put in my report that General Cermak has command over these units.
No, that's right. But you've read the indictment and you may have forgotten the indictment. And the indictment at paragraph 7 describes Ivan Cermak as possessing effective control over members of the HV units or elements who comprised or were attached to or operated in the Canadian garrison, and also over the civilian police who operated in the garrison area. And then it describes the HV units without limitation, 4th, 7th Brigades, 1st Croatian Guards Brigade, 113th, 142nd, 144th, 126th Home Guard, the 6th and 7th, 134th, a combined military police company, members of the Zadar and Kotar police administrations. I appreciate the civilian area is outside, in a way, that your position. But looking at all these military district documents, we've looked at a few here which go to a particular issue, but there, as you know, are thousands in relation to all those units. General Cermak is copied in on a handful of matters, isn't he?
It is correct, and I think that's also visible through my report, that there are very few orders by General Gotovina to the Canadian Garrison Command or the Canadian Garrison Commander during the time period. General Cermak is the commander of the Canadian Garrison.
My question is about General Cermak having effective control over all those units. They're all operating every day in relation to their activities, where they go, what they do, completely independently and without General Cermak. That's right, isn't it? What I'm putting to you is that paragraph 7 on this indictment doesn't fit with your expert's report.
That may well be possible. I mean, I haven't, I read the indictment once, as I mentioned, at the very start of the report project, in order to determine time frame, locations, and other relevant aspects. Otherwise, I have not been influenced or was bound anyway by what is in the indictment. My findings or my conclusions in relation to the role of General Gotovina as a clean garrison commander are included in my report, and more specifically in paragraphs 49 to, I believe, 51 of the executive summary.
I hesitate to say you demoted General Gotovina to the garrison commander, but
I apologize.
It won't be controversial.
No, it should read Cermak.
Yes.
I'm sorry.
But what I'm putting to you is right on that passage of the indictment that I read out in relation to paragraph 7, which asserts that Ivan Cermak possessed in various structures of power and responsibility and possessed effective control over all those units. They're all the split military district units that we are familiar with, is in fact not borne out by your expert's report, and indeed all the documents that you have seen. It's right, isn't it? I'm right.
Yeah, I mean, I haven't addressed effective control, and I haven't seen any material, I mean, documents on that aspect concerning the role of General Cermak as the commander of the clean garrison.
Thank you very, very much, Your Honour. I've just had a note that Mr. Misetic needs to address you urgently. And
thank you very, very much. So that was a snippet of a cross-examination that probably took about a day of the prosecution military expert on a key component in the indictment against my client, General Cermak. And effectively, the indictment fell away completely because the allegation was, and Andrew will remember this, having worked with me on the case, that he was in command of all those military units and responsible for the acts that they did that were alleged to have been war crimes. Now, you will have noticed in that snippet that I speak much slower than I normally do in an English court. And that's because you've got 3 judges of different nationalities. We had in that case a judge from Zimbabwe, a judge from Estonia, and a judge from the Netherlands. And some judges don't speak, may not surprise you, perfect English to understand everything that's being said. And they're listening to a translation into English by interpreters. The interpreters are also translating, because that is broadcast back into the territories of the former Yugoslavia, now the independent states, in Serbo-Croat, in Albanian, and probably a couple of other languages as well. So a courtroom at an international criminal tribunal, and indeed at the ICC, where James has practiced for 10 years, is a courtroom that is structured to internationally broadcast what takes place in the forum of the court. And it's very important to remember in your advocacy before tribunals such as these that you have to get your message across. And there is a live note with a recording of what is being said by a stenographer. And if you notice that something has been mistranslated, someone on the team would pass a note, or you'd notice it yourself, so that the record was accurate and the questions that you deliver further down the line are based upon an accurate premise that the judges understand. So the advocacy in an international court takes into account the variety of judges, the place where the allegations that arise, so that what has taken place is transferred into the hands of an international court, so that everyone can understand what is taking place. The proceedings themselves are adversarial in nature. So you have cross-examination, you have examination in chief, you have the usual order of witnesses. But the judges who sit may not be from a common law jurisdiction or adversarial jurisdiction. They may be civil code judges, and with their training and perspective on how a case should be run as a judge, approach it entirely differently from a judge or a group of judges from the same judicial background. For instance, in the Tardich case, we had a presiding judge from the US, we had a judge from Australia, and we had a judge from Malaysia. And that being the first case in the international tribunals, we all had to work out together a way of operating together. And that included putting your case. And it was agreed before we started the Tardich trial by both prosecution and defense that we would put our cases to the witnesses so that the challenges of the parties were understood. And I think you hear me in that clip saying, I'm putting my case to you concerning counts 7 of the indictment. Now, or paragraph 7 of the indictment. Now, the next case I did, which was in Rwanda after the Tardich case, was the Rwandan tribunal established by the United Nations, where there was a judge from South Africa, a judge from Sweden, and a judge from Senegal. And he was the presiding judge and had a very fixed view of how the proceedings should be run according to the French civil code system. And when I put my case there, all hell broke loose as he accused me of insulting the witness and was completely exasperated. Whereas the South African judge understood what I was doing, and the Swedish judge was quite happy to accept that. So we had a very difficult passage during that trial in how to negotiate the advocacy. Now, that's enough from me at this stage. And I thought it was important you could see that clip just to get a flavor of what the advocacy is about. And I'm now going to turn to James to deal with the focus on appellate advocacy, which is an art in itself, I can tell you. Thank you, James.
Well, thank you very much, Stephen. And I think we will pick up on some of the themes that you have very helpfully announced. And I just wanted to say, first of all, that I am delighted to be here. And I'd like to thank the International Committee of Intertemple and Josh for his invitation to participate in this panel. Thank you. And so my topic, as you know, is appellate advocacy before international criminal tribunals. And I'm going to be speaking purely, I have to say this, in my personal capacity. So I'm going to focus on appeals before the Appeals Chamber of the International Criminal Court, or ICC, based in The Hague. But of course, I will make some reference to other experiences that you've heard about. And I'm not going to get into all of the minutiae of appellate procedures before the ICC, but I'm going to concentrate on interlocutory appeals during trial and post-trial judgment and sentence appeals. And even there, I'm not going to cite a single article from the Rome Statute, the legislation governing ICC appeal procedures, the rules of procedure and evidence, or the regulations of the court, but I'll outline in broad strokes, in a way which I hope is going to be helpful, the basic features of ICC appellate advocacy. Now, there are a broad range of appeal rights at the ICC, but the appellate processes that I'm about to describe are central to practice at the court. All right, there we are. I'm going to organize my talk around three topics. First, I will make some brief general comments about appellate advocacy before the ICC Appeals Chamber. Secondly, I will outline the general framework within which appeals are conducted at the court, including some particular features of appellate advocacy. And finally, I will offer a little bit of advice. I think you've got some very useful advice already. A little bit of advice on successful advocacy before the Appeals Chamber. You blotted out my picture. I'm just kidding. Yeah, okay, now I've got it. Oh, am I all right? Am I okay there?
Yeah.
There's something at the side which should be not there. Yeah, that shouldn't be there, whatever that is. Yeah. Right. All right. So my general comments on appellate advocacy are these. It's really all in the writing. This is true in Canada. Where I'm from, it was true at the International Criminal Tribunal for Rwanda, or ICTR, where I was involved in appeals, and it's true at the ICC. What I'm saying is that at the oral hearing, the bench pretty much knows what it's going to do based on the written submissions of the parties. It's not like a trial where the judges have to keep an open mind, hear all of the evidence, and hear all of the argument. They've got a record, they've got the written submissions, so they've got, I think, a pretty good sense of where they're going to go. The notice of appeal sets out the grounds of appeal with specificity at the ICC, and the appellant and respondent develop in detail their arguments in support of their positions, respectively, in the document in support of the appeal and in the response. Now, at ICTR, we understood that the judges already would have a draft judgment in readiness. There were things they wanted to hear about, but they would basically have a draft judgment in readiness when they came to the oral hearing of the appeal. And I don't know how far advanced the ICC appellate judges are in their thinking. They may not have hardened their position on issues in the case, but I suspect that they're pretty far advanced in their thinking by the time they come to hear counsel in the oral argument, based on the extensive writing that they will have been through. In fact, at the ICC, appeals don't even have to have oral hearings. It's in the legislation, but the practice has grown up especially for post, in fact, entirely for post trial judgment and sentence appeals. The practice has grown up of having oral hearings. And I'm going to come back to written appellate advocacy, of course, later in the talk. I mean, oral hearings have become important, and they can stretch over several days. A final comment on appeals at the ICC. They're based on the record of the proceedings below, as they are in Canada and here in England and Wales, and as they always were at the UN International Criminal Tribunals. ICC appeals are corrective. They are not trials de novo, unlike certain continental systems where in essence the matter is retried. That doesn't happen at the ICC. It's very much like it is here. Counsel, I think, sometimes forget this because we saw appeals that were filed challenging practically every factual finding and every decision that the trial chamber had made. But it is an appeal on the record. Coming now to the general framework within which appeals are conducted at the court, including some particular features of appellate practice there, I'm going to focus, as I said, on interlocutory appeals and post-trial judgment and sentence appeals. The appeals chamber dealing with such appeals is composed of the president of the court and 4 other judges. In other words, you have a panel of 5 judges hearing the appeal. To illustrate some points I wish to make, I'm going to refer to the Ndiganda case. You see Bosco Ndiganda up there, which has recently run its full course at the ICC. And the Ongwen case, you also see Dominic Ongwen, where judgment in appeal, or on appeal, I should say, is currently reserved. It's been heard, but it's reserved. And I'm going to make passing reference to one other case. Just for your background information, Bosco Ndiganda was a military commander known as the Terminator, and he was convicted of war crimes and crimes against humanity for which he was responsible in the Curie region of Eastern Democratic Republic of the Congo. He lost his appeal and he is now serving a 30-year prison sentence, and the matter of reparations is ongoing for victims at the court now. Dominic Ongwen, a brigade commander in the so-called Lord's Resistance Army, who committed atrocities in northern Uganda, was convicted of war crimes and crimes against humanity and sentenced to 25 years in prison. His appeals were heard recently. I think I can start. I'm going to talk now about interlocutory appeals, and there is a lively interlocutory appeal practice at the ICC. Such appeals are heavily discouraged in Canada. So it's the one after that. Yeah, there we are. Leave it there. That's perfect. They're heavily discouraged in Canada, and they were quite rare at the ICTR, but they are common, or at least efforts to launch them are at the ICC. Nevertheless, interlocutory appeals are very tightly controlled at the ICC. A party wishing to file an interlocutory appeal must seek leave from the trial chamber to appeal against a decision and do so on specified grounds arising from the decision. There is an exception with respect to decisions on jurisdiction and admissibility of a case, and a very few other issues where appeals are as of right, but this exception has been narrowly construed by the appeals chamber. Most requests for leave to appeal are denied by the trial chamber because they do not meet the criteria stipulated in the statute. An example of a successful request, however, may be seen in the Ndiganda case. There, the defense wished to challenge a decision of the trial chamber upholding the ability of the prosecution to bring charges against the accused relating to the sexual exploitation of child soldiers within his own ranks. Now, usually the law of armed conflict, which is part of the system of law underlying the Rome Statute, is outward looking. That is, the law focuses on the protection of an enemy's population or enemy combatants who've been wounded or laid down their arms. Here, the trial chamber found that the protections afforded to children under international humanitarian law, which is also relevant to the court, extends to children conscripted into the ranks of the armed group commanded by an accused. And so the law of armed conflict is also inward looking, so to speak, and the prosecution was within its rights. In granting leave to appeal the decision, the trial chamber was satisfied that the grounds of appeal, which it certified based on the defense request, arose out of the decision. Put those up on, no, stay there, yes. No, you've gone 2 ahead. No, please, backward. Yes, stay right there, thank you. So the decision arose out of, the appeal arose out of the decision. It involved an issue that would have significantly affect the fair and expeditious conduct of the trial or its outcome, and for which an immediate resolution by the appeals chamber might materially advance the proceedings. So those are really the criteria that the trial chamber has to be satisfied upon to allow a matter to go up to the appeals chamber. Now, in the result, the appeals chamber agreed with the trial chamber's decision and denied the appeal, and Ntaganda was ultimately convicted of the offenses in issue. And this interlocutory appeal, like all such appeals, was dealt with entirely in writing. There was no oral hearing. Now we can go to the next one. Thank you. All right, thank you. Thank you. I can signal to you. Post-trial judgment and sentence appeal rights are very wide at the ICC. This was also the case at the ICTR and other international criminal tribunals and special courts. At the ICC, a convicted person may appeal as of right on the ground of procedural error, error of fact, or error of law. A prosecutor may also appeal as of right on any of the same grounds. And this is in contrast to the right of appeal of the Crown in England and Wales, as I understand it, or in Canada, where the Crown may only appeal on the ground of a question of law alone. In addition, at the ICC, a convicted person may appeal on any other ground that affects the fairness or reliability of the proceedings or decision. I should add that the statute also empowers the prosecutor to launch an appeal on behalf of a convicted person. Right. Oh, thank you. To succeed on a ground of appeal alleging procedural error, an appellant must be able to show that absent the error, the decision would have been different. And this can prove to be a difficult test to meet, because in some ways it's a bit speculative as to what would have happened had the decision not been made. So it's quite a tough test to pass. The test for error of fact is reasonableness. Even if the appeals chamber might have concluded differently on the facts, it will not interfere if the findings of fact made by the chamber below were reasonably reached. Now, this is an approach that's familiar to you. It's commonly adopted here in England and Wales, in Canada, and elsewhere in judicial systems influenced by British legal traditions. And it was the approach taken at the ICTR and other international criminal tribunals. This approach, which involves a certain degree of appellate deference to the fact-finding responsibility of the trial court, wobbled a bit in the Bemba case at the ICC. And there you see Jean-Pierre Bemba on the screen. There, the appeals chamber, in a 3-2 majority decision, overturned a unanimous judgment of the trial chamber convicting the appellant, arguably on the basis of a much looser test for error of fact. But this situation has since righted itself through subsequent appellate judgments, and reasonableness remains the test at the ICC respecting appeals on alleged errors of fact. Respecting errors of law, of course, the appeals chamber does not have to show any deference to the chamber below, but may take its own view of the applicable law. Sentence appeals may be taken as of right by the prosecutor or the convicted person on the ground of disproportion between the crime and the sentence. To mention the Ntaganda case again, the defense appeal against conviction and sentence were broadly based, challenging almost every aspect of the trial, proceedings, and their outcome. And here are two small extracts from the defense notice of appeal, just to illustrate the breadth of the appeal. And to date, such multiple ground appeals are typical of defense appeals. Prosecution appeals, when they're taken, tend to be more surgical. Now, I should add that although there is provision for fresh evidence to be introduced on appeal at the ICC, and motions to do so are filed, fresh evidence has so far not played a prominent role in ICC appeal processes. And this is in contrast to our experience at the ICTR, where fresh evidence motions on appeal were common, as were fresh evidence hearings. All right, I'm going to leave it there for now. At least you have a general sense of the framework structuring certain important appellate processes at the ICC. I'm going to come to some particular features of appellate practice. And given time, I will only mention 3 particular features of appellate advocacy at the ICC, namely the tight programming of appeal hearings, the participation of victims, and the role of Amici Curie in appeals. Now, oral hearings are carefully orchestrated by the Icc Appeals Chamber. In Canada, I expected almost half of my time on an appeal hearing and an appeal hearing to be devoted to fielding questions from the judges, knowing that the judges would engage with counsel. And at the ICTR, we used to receive a scheduling order from the appeals chamber in advance of the hearing, which left it open to counsel to pursue any argument they wished to pursue, but outlined certain issues on which the judges wanted to hear submissions. And these might be issues where there was disagreement among the judges we didn't know, or matters of importance that the judges wanted counsel's advice on at the hearing. And so we prepared our oral submissions accordingly. Now, the Icc Appeals Chamber issues similar orders, but they're far more detailed and specific on time controls. Now, in any appellate court, oral argument is almost always time controlled. However, the orders issued by the appeals chamber not only identify specific issues, as I say, of concern to the judges, but also tightly prescribe the time the parties and participants may devote to addressing them. So there's often little room left, not always, but often little room left to counsel to open generally or to pursue matters that they feel should be highlighted. And I'm going to give you an example. Here's two slides, just an extract from the directions given from the order regulating the conduct of the Ongwen appeal hearing, setting out in fine detail the schedule of submissions to be made by the parties and participants. Here's the extract continuing just up to the break for that day. And this approach, while being very helpful because it's revealing about the thinking of the bench, the appeal bench, it does pose a challenge for counsel to be efficient, on point, and well-honed in addressing the issues raised by the judges. Another feature of judicial proceedings at the ICC is the space given to victims of crime, including in appeals. Victims have legal representation, and while victims have very limited rights of appeal confined mostly to issues affecting reparations, counsel representing victims file response to appeals by the convicted person or the prosecutor, and they participate in the appeal hearing. Now, this is a feature that may be unfamiliar to many of you, and it is to a degree a unique aspect of judicial proceedings at the ICC. A final feature I'd like to mention is the role of Amici Curie in the ICC. In some appeals, such interveners have played an important role. Amici must apply to the appeals chamber to be let into the hearing, so to speak, and demonstrate that what they're going to have to say, usually on a point of law, will be of genuine assistance to the chamber. They participate at the discretion of the appeal judges, filing briefs of argument, and in some cases being heard at the appeal hearing. An example arises from the Intiganda appeal hearing, where Amici participated in the hearing on the issue of the scope of the word attacks in relation to the war crime of intentionally directing attacks against hospitals and places where the sick and wounded are collected, provided they are not military objectives. The trial chamber had taken what the prosecution felt was an unnecessarily narrow approach in the interpretation of this provision and had appealed on this point. In the result, the prosecutor's appeal was dismissed. So finally, just some advocacy pointers which pick up a little bit on what Stephen has already said. I'm probably going to be telling you what you already know, but and I'm focusing on oral advocacy, but what I say applies to written advocacy as well. It's key to capture the attention of the judges in a vivid way on any point right from the start. You've got to get their attention and capture their imagination right away in addressing an issue, in my suggestion. Even on specific issues, persuasive advocacy should provide the context, that is, the result you seek and why, before the detail, namely the arguments in support of that outcome. And this approach makes your submissions far more accessible to the bench, and this is key to successful advocacy. I mean, put yourself in the place of the judges. Why should they find your position compelling? And if they do, how does the law take them to where you want them to arrive? In other words, if you can convey to the judges that on the facts you have right on your side, help them understand how the law takes them there as well. Now, Stephen has said, and I think this is very important, remember that many of the judges hearing your argument do not have English as their first language, even though they may understand it very well. And some may be listening to interpretation into French, the other working language of the court. And this is common at appeal hearings. So plain speaking in simple English active voice, avoiding idiomatic expressions, and regular pacing, as you saw in the video clip, in oral submissions become important to your ability to persuade. Your bench will invariably be composed of judges from different legal backgrounds, so adjust your approach, as Stephen has suggested, focusing, for example, on underlying principles and avoiding terms of art that you're familiar with in a domestic setting, but mean nothing to judges from other backgrounds. And use questions from the bench, no matter how apparently hostile, to persuade the bench of your position. After all, some or all of the other judges may be with you. Follow all the rules of honesty and candor that you would hear at home, and good luck. I'm going to leave it there. I hope I piqued your curiosity to look further into the realm of appellate advocacy at the ICC and to learn more about the appeal processes in the world's only permanent international criminal jurisdiction. So thank you for your attention.
Thank you, James. Efficient and honed, I think you've given us an example there. Kirsty, you're going to explain to us next what the trends are at the ICC, because you're currently engaged on a trial at the International Criminal Court. So, Kirsty, can we hear from you?
Well, I'll try to honour that. I'm obviously an extremely lofty company, but I've come fresh out of the trenches, so it's I'm actually in my sort of R&R, so forgive me if I'm a bit bleary-eyed about it. It's all a bit raw. It's a tough environment. One thing I wanted to pick up on again is the language point that's been made by both Stephen and James, which is, as somebody who's just been in the courtroom, I spent a lot of time sucking up outrageously to the interpreters because I relied very heavily on them. They made me sound amazing in French, even when I was exhausted and not making much sense. But we did have some interesting moments there. I had one very tough day where my language just wasn't working. I was thinking a lot on my feet, the sentences coming out of my mouth were really causing problems for the interpreters, and they were getting a bit stressed out with me. And very helpfully, actually, the French prosecutor came over to me in one of the breaks and said, you know, the trouble you're having is that your English is too good. And the complexity of your sentence structure, as you think on your feet, is so far beyond any other, even native English speaker. It's British English, it's Shakespeare, they can't translate it. And that was actually incredibly helpful of him. And then I found out that apparently the interpreters have an ongoing thing where if they lose a bet, they have to interpret the Brits. So which was brutal, but very important information. And it did change the way that I learned to speak in the courtroom. We also had some instances where, of course, everyone sort of speaks a sort of franglais at the ICC, and our French opponent, my opponents were generally French speaking, and we were Anglophone, but we could understand what they were saying in the courtroom in French, and we would respond very quickly in English, and then they would respond in French, and the interpreters couldn't keep up, and we'd get lots of quite foul language from the interpreters. Counsel, stop. So yes, it was interesting. And then I had a lot of vulnerable witnesses who spoke very uncommon ethnic languages. And so we had not just simultaneous interpretation, but consecutive interpretation, which really radically slowed the proceedings down. So we would have to take these long pauses between questions. There were lots of issues with interpretation and just the accuracy of those. And James has mentioned the time constraints that were imposed, and the language issue actually became really problematic, because 10 minutes where you've got multiple layers of interpretation going on really becomes 5. And it can be a real struggle. But anyway, I wanted to talk briefly about the sort of difference in environment between the domestic and the international settings. And from the defense perspective particularly, it's pretty tough, I'll be honest. We don't enjoy the same respect as one would in the domestic setting or here, and specifically in this country. It's a bit different in America and France, where the French is also, the defense is also sort of looked down on. But here, I think we enjoy quite a lot of respect, and in the international tribunals, it's there's quite a lot of a feeling of public hostility towards you and questioning how you can defend these monsters. The cause of public opinion, frankly, is often already won over by the fact that charges are being brought, and you have that narrative to counter. This has a real impact, and I know Stephen's spoken about this in several environments, but has a real impact on the willingness of witnesses to testify on behalf of the defense. It has a real impact on the narratives that become entrenched and repeated by witnesses who may be repeating narratives that have become entrenched at home because of NGO advocacy that's preceded the ICC investigation, all sorts of things. So it's a quite pernicious thing. And then, of course, this is amplified greatly by the fact that the proceedings are televised. In the recent case that I've just come out of, my role was largely in the courtroom to be cross-examining complainants of sexual violence. Now, it's not great. It's not a great feeling being looked at as the sort of face of telling these women that they're lying, which is not, of course, what I was doing all the time, but there is a sort of feeling of antipathy from the public, and it's not an enjoyable position to be in. But then I was also in the very strange position of my opponents sort of privately thanking me for how I was handling their witnesses and doing it, to the standards expected in this jurisdiction, and with the sort of sensitivity that is required. And you sort of think that you're the lesser of the evils available in questioning them. So it's a difficult position, and not that much fun. Another thing that's a huge difference between the international environment and the domestic environment is resources. The defense just doesn't have the same resources as the prosecution, and on top of that, lacks the same access to states and international organs. It may be that in writing we're expected to have the same access, but in practice that, I'm afraid, just doesn't seem to be the case. The reality is the defense won't enjoy the same warm welcome in every situation, and my experience, and it will be different across different cases, but my experience is that, frankly, this is exhausting. Another difference is the culture of hostility between the parties that can, if you're not careful, grow through cases. The consequences, I think that's the consequence of how long running the cases actually are, and how devoted to the cause people become, and emotionally connected to the case, because that's their lives. They're consumed by it. It's not the same as in the domestic environment where you're doing multiple cases at the same time, and you learn to have a sort of professional dispassion from the case. When I arrived in the case that I've just come out of, there was a sort of open hostility, and I found myself thinking, well, this is completely intolerable. We're not going to get through the months and years of this case if we can't cooperate. And so it sounds really trivial, but every morning I would cross the courtroom, say good morning to everybody, introduce myself by my first name to my opponent, learn who they were, to de-escalate everything, treat them with respect, and sort of explain that I expected to be treated the same way. And that after a few days of this, they sort of said, why do you keep crossing the courtroom? And I said, because it's just a professional courtesy, and I'll thank you at the end of the day. And then they started doing it in response, and actually built real bridges, and was very helpful. So I would recommend that. The courtrooms are pretty aggressive. I don't know if my esteemed colleagues will agree with that, but I found them, compared to being in an English courtroom, quite tough. We had to deal with objections, which were completely unnatural to me, and frankly I thought they were a bit barbaric. I had to learn to be occasionally quite feisty in response to objections made while you're on your feet, and intentionally disrupting your flow and this sort of thing, games that are played. I found it very interesting, the behavioral impact that having the objection system has, which is that instead of parties sort of self-marshalling because they know the judge is going to intervene if they cross any line, they see, I don't know if you'll agree with this, but people try to push the limits and see what they'll get away with. I found myself in slightly bizarre situations where, one example was my opponent led his witness on the central issue. I, of course, objected, and the judge, his response, accepted that he had led, but said that he had done it to save time, even though he had hours left. And the judge said, "Well, Miss Sutherland, you see, he did it to save time." And I found myself standing there, sort of completely bamboozled, because I just thought, well, how do I diplomatically explain to the judge that it's not okay, or what a leading question is, and why it's not okay for the prosecutor to have done that? And then I found myself thinking, well, they now can't rely on this witness, but I actually have no faith that that won't happen. So it was, yeah, I mean, it was crazy. One of the things we have to bear in mind is that we're focusing on the ICC, it seems, but the ICTs do have different formats. And the ICC is a mixture of the common law and inquisitorial systems. And I think this blend can be occasionally uncomfortable and sometimes dysfunctional. But at the ECCC, which I think Andrew's going to speak about in detail, they follow essentially the French system because it's based within the Cambodian judicial framework. Now that's potentially difficult for common lawyers to navigate. I was really lucky in that I worked for a very experienced civil practitioner, and she taught me much about how to handle that early preliminary civil system in a way that would enable you to be effective at trial. What she taught me is that it's critical to participate in the pre-trial investigation and evidence collection by so in the Cambodian system, the French system, the pre-trial investigation is handled by an investigative judge rather than the prosecution and police. And you can, as a defense, have to make requests, investigative requests as well. And if you don't do that, then you're going to have trouble at trial. And I think that common lawyers perhaps don't understand the importance of that early intervention within that system. And that includes making applications at that point on the scope of the investigation and the scope of the charges. It's not just a matter of sitting back, waiting for the trial to start and holding the prosecution to account. We have to be very active at that early on. It's obviously a very different matter at the ICC. The pre-trial there is sort of has a civil law flavour, but the investigation is conducted by the prosecution. The scope and the charges are determined by them, and of course, subject to review by the pre-trial chamber. The defence becomes involved really at the arrest warrant stage, and then at the trial, and can conduct its own investigations. My feeling is that it's critical, having learned from Stephen, that it's critical for defence investigations to really get off the ground as early as possible, so that you can be in a strong position at trial or get everything kicked out at pre-trial. But others have taken the view that they just sit back and wait for trial and see what happens, and then investigate later. My feeling is that's quite dangerous. It's not really how we do it here. Again, trials at the ICC, I think, are hamstrung by the differences in resources between the prosecution and defence, which has huge ramifications for trial rights. And I think this is probably the major fault line that we see in international law. And in the interest of time, I'm going to wrap up, but make some suggestions about areas that we may want to cover in questions. which lie around expert evidence at the ICC and gender dynamics. If I could welcome any questions about that, then I would be very welcome. But yeah.
Thank you, Kirsty. Thank you. Yeah, leading questions in international cases are a big problem and often a big mistake when they do happen and the case blows up because the leading questions have been on a dodgy witness, and then there's much embarrassment and apologies. Andrew, great to see you again after a few years. Andrew and I were in the case of Chermak together. And Andrew, you've settled some pretty heavyweight indictments in your career, as well as done heavyweight prosecution openings. And I certainly believe there's an art to that as well. Perhaps you can tell us how you do it.
So what's quite interesting for me, actually, listening to everybody speaking, and I don't say this out of conceit, it's a fact, I'm the only person here that's both prosecuted and defended in these trials. And there are a few other lawyers who've done that. I make the point because I do agree with the defense lawyers who've spoken that I think these cases are very difficult to defend. And when I moved from the prosecution to the defense, I was astonished actually at some of the dynamics defending, which, you know, as Kirsty says, they just don't exist in this jurisdiction. I think it's heavily dependent on the judges, because remember that there's no jury, so it's a judge-only court. So the exclusionary rules of evidence that you're used to in England and Wales, because obviously certain kinds of evidence are held back from the jury in this system, everything basically goes in, absolutely everything, including, you know, what Steve has just referred to, you know, leading dodgy witnesses with evidence that's unreliable, which would never go in front of a jury in this country, but it does sometimes go, and it's heavily dependent on the judges. If you get decent judges, often I'm afraid from common law jurisdictions, I've got to say that, it's probably a bit unfair to make that generalization, because I have known and appeared in front of some good civil law judges, but I think most of the most competent judges come from common law jurisdictions. But I do agree that these cases are very, very difficult to defend. I'm not saying the prosecution has an easy job. They're tough, these cases, whether you're prosecuting or defending, but I think the prosecution does, generally speaking, have the moral high ground in these cases because of the nature of the crimes. Anyway, I don't have much time, so I'm going to talk about two cases. The first case is a case that I led actually back in, looking at it, in November of 2004. I was only 15 when I prosecuted this case. But it's 18 years ago, and it was actually a case called the Prosecutor against Leone, Rouge, and Haradinaj, and it was an interesting case because it was the first prosecution of members of the Kosovo Liberation Army. So the Kosovo conflict, which you may remember, it's 20 years ago now, this was when Serb security forces effectively attacked on a massive scale the civilian population in Kosovo, hundreds of thousands of whom fled from Kosovo. And so the point of this is that most of the very, very serious crimes were committed by Serb security forces against Kosovo Albanians. So Kosovo then was an autonomous province within the former Yugoslavia. It was inhabited by both Serbs and Albanians. And the Albanians had frankly been discriminated against and marginalized for decades and decades and decades. And you might remember Slobodan Milosevic used Kosovo and the conflict and tension between the Serbs and the Albanians as the kind of touch paper for the whole of the Yugoslav conflict, to break down the assertive nature of sort of Serb dominance within the former Yugoslavia. Anyway, you can imagine, so I am now leading in a case where we're prosecuting the victims. That's how it was seen, even though the KLA had committed crimes. The Kosovo Liberation Army, the Albanians, they had committed crimes, not on the same scale as the Serbs, but they had committed crimes. So you can imagine opening this it had to be done very, very carefully. And on the other side, interestingly, I had Michael Mansfield, QC, and Kareem Khan, who is now the prosecutor of the ICC, but in this case, he was defending, he was Michael Mansfield's junior. So I had to acknowledge in this case from the outset that we were obliged to prosecute all crimes that were, before the court had jurisdiction over. We couldn't just only deal with the biggest offenders. I mean, actually, in this case, I'd forgotten there were 20 individuals who were murdered, which from a domestic perspective sounds immense, but actually in the context of those cases, there were people in the office asking me at the time, why on earth are we prosecuting a case with only 20 dead bodies? I know that sounds terrible, but when you look at Srebrenica, which is a case that I was a junior on, there were 8,500 bodies. If we'll come to Cambodia in a minute, we had 2 million dead in Cambodia. So this case was small in terms of its size, but these were people who had been murdered. They'd been beaten to death or shot, taken to a makeshift prison camp. Serbs and Albanians, actually. Interestingly, they were killing their own people. So the KLA were killing what were known as loyal Albanians, so Albanians who were loyal to the Serb authorities in Kosovo. They were rounded up and killed. It was a relatively straightforward case, and I'll just repeat what I said in opening. The essential facts of this case are straightforward, as they are compelling. The prosecutor will show that between May and July of 1998, Serb and Albanian men were abducted and unlawfully detained in a makeshift prison camp in the village of Lapushnik in Kosovo. Here they were brutally beaten, tortured and mistreated, in over 20 instances either beaten to death or killed by fatal gunshot wound. The three accused before you, Fatmir Limai, Isak Musli and Haradin Balai, bear responsibility for these events. So it was actually a very straightforward case. If you look at the rules of the ICTY, so this was a case, sorry, I should have said before, the Yugoslav Tribunal. I haven't looked at these rules in ages. Rule 84 deals with opening statements before the court. All it says is, before the presentation of the evidence by the prosecutor, each party may make an opening statement. That's it, nothing else. So you have to kind of work out what you do. So effectively, I dealt with it in exactly the same way that I would have dealt with the case here, except I had to also realize that this was being transmitted to the public. And so it was televised and it was going out to Kosovo. And I knew that, and I knew this case was enormously unpopular in Kosovo. We had terrible problems with witness intimidation. It was seen, anybody cooperating, Kirsty's made the point that the cases that she's dealing with, we had the problem as prosecutors that nobody wants to cooperate with us because the Kosovo Albanians saw themselves as victims. All members of the Kosovo Liberation Army were heroes. Nobody should go and give evidence. So I had to try and transmit a message into Kosovo to make people understand what this trial was about. Now, I acknowledged in my opening statement that the Kosovo Albanians had suffered in this war. I acknowledged that. I said they were victims. I said that they had suffered the predominant, the largest number of crimes had been committed against them. But my position was, even though they were freedom fighters trying to get independence, my exact line, I looked it up, was no cause, however just, legitimizes indiscriminate murder. So even though they were looked upon by the international community as being in the right, they couldn't murder innocent people in that process, however they were viewed. As I say, I accepted all of the crimes committed by the Serb security forces because Michael Mansfield rightly accused me of sort of rewriting history around this. I mean, somewhat unfair. It's a legal case. We weren't, complete. The other problem we had in this case, and I'd forgotten this, is that we'd arrested the wrong person. We had arrested 4 people, and the 4th individual has been the wrong individual. And it was interesting. It's one of those situations where, and you probably won't believe this when I tell you, I had objected to the indictments of this particular individual. His name was Agim Murtazi, because the descriptions of him varied wildly. And I always felt in any kind of case involving war crimes or crimes against humanity, if it's a case that's based on identification evidence, you should not be bringing it. You do not want people trying to describe people they've seen in a prison camp or anything like that. Anyway, we arrested this guy. It was absolutely clearly the wrong bloke. You know, they'd smashed the door of his house down. You know, he arrived in court, you know, with a black eye and missing teeth. It was absolutely awful. And I always remember, you know, I'd been against indicting it, but of course I had to go back to court and make the application to release, you know, and I was there completely alone in the court of the prosecution. Everybody was so shot up. You know, everywhere else, you know, let Cayley deal with this. If you'll if you Google it, you know, Andrew Cayley, arrested wrong person. It's still actually on the BBC website. I get the glorious responsibility for that. So moving quickly, of course, structure of the indictment and charges, dealing with the criminal conduct, modes of liability for all three accused, short biographical details of the accused. I had to give background and history of Kosovo because I knew that the judges probably wouldn't understand everything that had happened. And it was a requirement for some of the overarching jurisdictional requirements for the charges. So, for example, we had to prove there was an armed conflict. So we had to talk about the background to all of this. I think one of the things I really learned in this case, and other people have touched upon it, never oversell the evidence in your opening statement. I mean, I know that's important in a domestic jurisdiction, but I think it's ever so important in these cases because oftentimes the witnesses do not come up to the proof. They're effectively cross-examined. So always slightly play it down a bit. There were 20 victims. I wanted to tell the stories of these people, who these people were in life, to animate them before the court. Interestingly, I'd forgotten in this case, there was forensic evidence. We had found mortal remains were recovered, which demonstrated people had been savagely beaten, and we were able to identify people through DNA evidence. And I recall at the end of my opening in this case, I quoted a guy called Salimi, and he was a KLA commander. And he publicly stated in Kosovo that everybody should be accountable for crimes committed in the war. And I said this very slowly at the end because I wanted to appeal to Kosovo Albanians to say, look, one of your leaders is saying that everybody should be accountable. You cannot imagine. I mean, this guy came under such ferocious attacks in the local press. He actually then said publicly that I completely misrepresented him. that I hadn't accurately reflected what he said at all, which was untrue, but that was the strength of feeling in Kosovo about this case. Difficult trial, a lot of witness intimidation, people changed their evidence in court, really febrile atmosphere. Many questioned why we'd ever brought the case at all, which I disputed. 20 innocent people had been murdered. Quickly, I'll talk about Cambodia. Very different kind of case. 2 million dead. Murdered, worked to death, starved to death between 1975 and 1979. So this is 2011, the trial, talking about events in the mid-70s. Kirsty and Josh were both there, actually, for this. You know, this was a massive case. 25% of the population dead, country in complete ruins. I felt then, still do, these were crimes on a par with the Holocaust. So actually, strangely, it made the opening a lot easier because I could really do sort of broad brush strokes. It was a joint court. That was an interesting challenge. So I had a Cambodian counterpart. I had to write her opening too, get that translated into Khmer. We had to split, you know, the opening between us. She dealt with the crime base. I dealt with the links between the accused and the crime base. She went first because we felt that it was their court. The court was in Cambodia. The crimes had been committed there. It was important that she lead this because that, I think, was symbolic for the country and the people. So she went first and I went second. I think it was over about 2 days we opened the case. As I say, historic trial. I had to deal with the age of the three accused. They were very elderly people. I had to say to the judges, look, you know, you cannot have sympathy with these people. They've killed off a quarter of their own population. You cannot possibly look at their age and have compassion for them. I had to deal with the legal basis for the trial because international criminal law was in its infancy in the mid-70s, so I had to go back to a lot of Nuremberg and immediately post-Nuremberg law to give a proper legal basis for the trial. And then I had to give detailed evidence of structure of the party. There was a hell of a lot of evidence linking them. It was obviously a Maoist communist party that was in power there for 3.5 years. They were absolutely meticulous in record keeping. There were absolutely tons of evidence linking the three accused, in particular Nguyen Chia, Pol Pot's deputy, with the crimes. Just one last thing, and then I will finish, because I know we've got. I mean, I was really fortunate because obviously in a case like this, you can really sort of go to town because the crimes are so massive. And one of the things I was able to do was to quote Robert Jackson from Nuremberg, who a lot more eloquent than me. But one of the defenses of the three accused was that Pol Pot, the leader of the Khmer Rouge, was responsible for everything, and he was dead. And there were some wonderful lines that Jackson said, and I'll just briefly, it will take me a minute. Jackson said this at Nuremberg: no matter how hard we've pressed the defendants on the stand, they've never pointed the finger at a living man as guilty. It is a temptation to ponder the wondrous workings of a fate which has only left the guilty dead and the innocent alive. It is almost too remarkable. The chief villain on whom blame is placed, some of the defendants vie with each other in producing appropriate epithets, is Hitler. He is the man at whom nearly every defendant has pointed an accusing finger. I shall not dissent from this consensus, nor do I deny that all these dead and missing men share the guilt in crimes so reprehensible that degrees of guilt have lost their significance. They may have played the most evil parts, but their guilt cannot exculpate the defendants. Hitler did not carry all the responsibility to the grave with him. All the guilt is not wrapped in Himmler's shroud. It was these dead men whom these living chose to be their partners in this great conspiratorial brotherhood, and the crimes that they did together, they must pay for one by one. And I then immediately followed that by saying, and so the prosecution agree in this case that yes, Pol Pot and others now long past are responsible for the 2 million dead, but to suggest that this exonerates or can acquit the three living accused before you is an utter absurdity. These three men here were actors with Pol Pot. They planned and schemed for years with Pol Pot as to what would take place when they seized power in this country. So, I mean, that was really remarkable that I could draw on this incredibly eloquent language of Jackson at Nuremberg and use it in this trial in 2011. These were historic moments. I mean, it was a real honor to give that opening, because I think of all of the courts, really, even though it had a lot of problems, the Khmer Rouge Tribunal, in terms of political interference, it was really dealing with crimes that were on a par with the Holocaust. I better stop there now, as I think we've run over time. Thank you.
Thank you, Andrew. I think you've got a flavour of the history, the political context of the trials, the nature of the format that takes place in written form, oral form, how you've got to be light on your feet and adaptable in this very challenging and serious work. It's one of the most serious crimes on the planet. And of course, Andrew referred to Nuremberg, and those remarks of Jackson would have been in front of Sir Geoffrey Lawrence, who was also a member of this inn and the presiding judge at Nuremberg, whose portrait was in Hall before the renovations, but I didn't see it last time I went in. It's probably been moved somewhere else, but a very interesting figure in relation to this international criminal law. We're now going to take questions till 7:15. I'll work the room first of all, as the auctioneers say, and see if there are questions here before turning to the Zoomers, because that requires a bit of technology. So anyone gathered here who'd like to ask a question of this most distinguished panel I have here? Yes.
Thank you very much for the very insightful talk. I'm going to ask a very practical question, I hope. How long on average does a case last for. I'm a criminal practitioner, so for us, the criminal trial, well, until recently, would last for from beginning to the end 9 months. Let's say, I mean, over the years it's changed slightly, but I imagine it may take a little longer. And I just wanted to know how long from the beginning to the end when you get involved, and the trial aspect of it. How long does that normally take?
Let's go down the line, shall we? Because there are some long servers here. Andrew.
Yeah, I'll be brief because I think probably Kirsty's the best person because she's in the middle of it at the moment. They last too long. They just last too long. I mean, if I look at 2 years, 2 years, I mean, anything between 2 and 5 years, including, I mean, that's not including the appeal actually with the 2 years. I mean, I think probably with appeals, you're going up to 5 years. Oftentimes, I mean, that's probably the worst example, but Kirsty probably more up to date than I am.
Well, it's a slightly difficult question because with the different systems, there's a discrepancy as well. But in Cambodia, the case I was working on had been an investigation for 13 years. That was an anomaly, or thankfully, but obviously that raises some serious questions about expeditiousness that ultimately I think contributed to the case's end before it got to trial. But then the case at the ICC that I've been on, that's a 1.5 years of prosecution hearings. Client's been detained for 4 years. Defense case is ongoing, and that's probably going to be 2 years of trial, and then however long the appeal takes. But I think that one of the things that I struggle with in international is that it's very easy in these environments for people to become sort of, the ICC is said to be a kind of cross between a court and an international organization, and there is a kind of degree of complacency and staff attitude, and sometimes you'd have to say this is a court, there are people in detention and they are presumed innocent, and it can be tricky, but yes, too long.
Shall I give the unusual example of the Milosevic case, which was the daddy of them all, in terms of 3 indictments: Bosnia, Croatia, and Kosovo, airlifted out of Belgrade to The Hague, put on trial 6 months later, with 1 indictment that had been hastily prepared. Another 2 then came in about a month before the trial started. I think actually 1 was served after the trial had started, the Croatian one, and then 4.5 years in trial. But generally, the waiting time is probably 3 years, something like that, for a trial. James.
We sort of did an estimate of this kind of thing. It varies greatly, but there's a process at the ICC that's unique. It's called preliminary examination. So in other words, nobody's on trial, nobody's accused of anything, but there's an assessment of information that's being received by the Office of the Prosecutor to see whether or not crimes have been committed and whether there should be an investigation. And depending on the particular situation, the prosecutor can either open the investigation if it's a state party referral, for example, or UN Security Council referral, or the prosecutor may have to go before a pretrial chamber for permission and authorization to open an investigation if he or she is acting on her own motion. So that those processes can take, well, it depends. I mean, they can be 2 years, they can be 6 months, 2 years, but in Colombia, it was about 15 years. Now there, of course, you had a transitional justice process that was ongoing. That preliminary examination has finished. The Colombians, there was never an intervention by the Office of the Prosecutor. The Colombians have dealt with the crimes that were committed during their tragedy themselves. But I mean, it varies greatly. But let's say we estimate out 2 years for a preliminary examination, 3 years for an investigation on average, and then you move a year of pretrial, at least a couple of years, maybe 2-3 years for trial. So you're looking at a long stretch of involvement of the court in a very complex, often very complex sort of situation. And then you go on to appeal. Now, what you're seeing now is an effort, I think, by the judges to tighten things up. Everybody knows that what is being said here is right. I mean, these processes are too long. how do we tighten them up without sacrificing people's rights or the ability to do justice?
Nuremberg took what, 6 weeks?
No,
The other way, the other way, the other
took
way.
1 year, but the preparation for Nuremberg was 6 months as well. So the charter was signed, and I think it was the May or April, and the trial commenced in Nuremberg in November. It took 1 year.
And they had 1,000 people on the prosecution team. I think some of our teams are maybe 4 or 5.
Yeah, and
Yeah.
no digital technology. Is
Right.
there another question in the room? Yes, madam.
Hi, I was wondering if you're familiar with the book by Nancy Combs, Findings Without Facts. She's a scholar in the University of Virginia who was analyzing the international criminal tribunals, primarily the ICTR. And she found that a lot of the cases, the defendants were being convicted on bad evidence because of linguistic and cultural issues. So a lot of the witnesses didn't really understand concepts of time the way we do in Western culture, or distances. And so people were being convicted based on findings where they didn't really even understand the questions that were being asked of them. So I wondered if you've ever experienced that.
I did the Musama case at the Rwanda tribunal, but James, there have been problems, haven't there?
Yes, I mean, I think I'll defend myself by saying that just before Stephen came to do Musema, I was involved in the first 3 trials, and we didn't have any insider witnesses. This was interesting. Thinking back on it, we didn't have insider witnesses. We never got inside the government in those early trials. But what happened during the genocide in Rwanda was that the people who were in government or who were leaders in the community were pushed out to sort of show the flag and promote the genocide. And they were well-known people, so that the witnesses that we called, who were often victims, but not always, sometimes the members of the majority ethnic group that were involved in the genocide, recognized these people and could report on what they were saying. So we were dealing with witnesses who I think understood perfectly what it meant not to just repeat what somebody else said, but to tell you what they themselves experienced. I mean, as a prosecutor, I felt responsible to be calling witnesses whom I believed. I didn't want to put up witnesses. I think there were some problems later on. There was the chap I call the Scarlet Pimpernel, who seemed to be everywhere.
Yes.
It was involved in everything, and he wasn't involved in our cases. But this notion of time, of distance, yes, but I mean, who are we in the West to impose our frame of reference, as long as you can get to the truth of what happened? Did this individual foment a genocide or not? Whether the person can, I mean, I can't estimate. I mean, how many meters is this? I don't know. I mean, so these witnesses, farmers, peasants, often had a very good sense of, you know, was it rainy season? Was it morning? Was it evening? But, you know, time, 8 o'clock, 8:10, who cares? It was not part of their culture, nor should we expect them to have that frame of reference. So although I haven't read the book, and I won't criticize it, there is perhaps, I suspect, a kind of a bias involved there that I think none of us who were involved with the witnesses or involved with Rwanda could really accept.
Yeah, I did the Musama case, which was the second trial at the ICTR. And I decided that the best way to approach this case was to prove an alibi. And I went to the tea factory where my client was the manager, and no one had investigated the tea factory. I went to the accounts department. There were all the receipts dated showing where he was, petrol receipts, car registration written down, because this was a Belgian-run system, and everything was documented. I'm satisfied I proved that alibi. However, one of the judges, and I won't name which one, in the judgment said I wasn't satisfied by the defense alibi. And I took that on appeal. I got thrown out on my ear is the best that I can describe. That judgment was written but it came at a stage when Rwanda had withdrawn cooperation from the tribunal because of the granting of conditional release to one of the accused. And that trial was done, all I can say, in a very hostile environment for a defense advocate to prove the innocence of his client, which was what was being expected. So that case still hangs with me to this day.
I find it troubling too, Stephen. Let me just say, one of the things that Stephen did that I thought was admirable was he went to Rwanda. None of the defense counsel we were up against in Rutiganda or Kaishima Ruzindana or Akayizu went to Rwanda. We did, of course, and we developed relationships, I suppose, with the local community to a degree. But you, Stephen, were courageous enough to go there, and I gather the Rwandans didn't want any harm to come to you, and you went and you you blazed the trail. But there again, you have to be courageous, I think, in the defense of your people. Yes, they're accused of terrible things, but maybe sometimes they're not actually guilty. You have to remember that.
Yeah. Any other comments?
I mean, I think.
Sorry, did you want to say?
No, go ahead. I'll go.
I think there's no doubt at all that that very famous saying that the first victim of war is truth. There's a lot to that. Now, I'm not suggesting, I've never prosecuted or defended the ICTR, so I don't know. If I look at the Yugoslav Tribunal, in the cases where I prosecuted, I would say that the largest amount of evidence was reliable, but there were people who had got serious mental health issues where it was obvious that their evidence was not reliable and we should not be relying on it. And if I look back, I think prosecutors had slightly different views about that. So if it was something that was very helpful, it might be put forward as the truth. And that's something that I found very difficult. And I'm saying, it happened in very, very few cases, as I recall. I think the vast majority of evidence was reliable at the ICTY, but we should not have been putting forward witnesses where we knew there were problems. We knew from other evidence that we had, incontrovertible evidence, that this probably is not the truth. It may be very dramatic, it may tell a terrible story, but it's probably not reliable. I mean, I remember one instance very quickly, because I know we're running out of time, but where a witness had described individuals being used as human shields, so digging trenches, and basically, civilians were being used to protect people digging military fortifications. So they're being shot at by their own people, basically. Terrible, terrible. And this witness told this account, a terrible account, as if he'd witnessed it. And when he came to give evidence, I remember I was going to be leading him. It turned out that it was about a fourth-hand story. So, not only had he been sitting at a bar, but the guy that was telling him the story hadn't witnessed it either. He'd been told. So, and that, we didn't call that witness. I mean, that, it does happen. Yeah. Kirsty.
I've just been asked to talk about Kenyatta and the telephone records, or what aspect of it? I was actually struck by the question, because I think it's a really important issue, actually, that is perhaps underlooked. So I find one of the most important. I have a master's in social anthropology and a degree in philosophy, and I found that actually maybe my master's in anthropology has been one of the most useful things in international law for me, because it's highlighted the ethnographic differences in evidence collection, etc., and that importance. But one of the, certainly in the case I've just done, the interpretation was a really big problem, and it's interpretation not just of language but of concepts. And I once had in response to a question about, I think the sophistication of questioning is seriously hampered, because you have to put everything in very, very kind of bite-sized, very gentle terms. And we were told not to ask leading questions in cross-examination by our bench in certain circumstances. And I got the response, "Why are you asking me about the color blue?" It was about location, completely irrelevant, so who knows what was going on. But I think that one of the dynamics that I observed that was quite interesting was that questioning women from a culture where they have no education, nothing. So they're streetwise. I'm not suggesting for a moment they're not very intelligent, but their frames of reference are completely alien to ours. And they are reliant culturally entirely on the men in their family for all decision making. The dynamic when they are questioned by a man and then questioned by a little girl is radical. And if the judges aren't alive to this, then I think it has a serious impact on their credibility assessments. And without everyone in the room being given an objective, thorough education in cultural dynamics relating to different ethnicities, different languages, before the trial starts, I think that the judges are severely impeded in their ability to make fair credibility assessments. And I think the parties are not going to be sufficiently informed to understand how to deal with the witnesses in an appropriate way. So I think that that's something that I've sort of advocated sort of behind the scenes quite strongly about.
I understand we've got some Zoom questions ready now. Would you like to present them, Jenny? Yeah, if you hand them over to me. Yeah. Yeah. That's fine. Yeah. A question that's asked by Joanna Corner of the ICC. And these parts is major criticism of international criminal trials is length. Does the advocacy bear any responsibility for the length?
Yes.
What do you think, Andrew? As
yeah, I mean, I think there is. Yeah, I think it is probably true that I just don't think it's, you know, exactly what Kirsty said about these courts being international organizations. I won't pick on the ICC. There isn't the same kind of urgency that exists in domestic courts, where you've got to get through a list in a domestic court, and you've got to get through these cases quickly. Now, of course, cases before international courts are much bigger, but I think things could move more economically, more efficiently. I think advocates could use their time much more wisely in these courts. Actually, both prosecution and defense, from my experience. I wouldn't only blame one party. I think it is true. Yeah. And I mean, if you look at also the written pleadings in these courts, I mean, particularly now at the ICC, I mean, it's insane the level that it's got to. And I mean, I don't blame the staff, because I'm not blaming James as deputy prosecutor there. It's the rules. I mean, the rules encourage it, as you see, interlocutory appeals about everything. I mean, and if you look at the filings, I mean, I try and look at cases there to try and understand what the hell's going on. And it's almost impossible because there's so many filings. And then you find that lawyers can just decide to make an additional filing, even though the rules don't necessarily permit them to make a filing. They file something else, and they don't follow page limits. So, you know, if their page limit is supposed to be 20 pages, they file 60, you know, and on it goes. And I think it just wouldn't work here in this country because the system would collapse. But that is partly the problem. I think Judge Corner's right about that. I think it could be done more efficiently.
It is partly the culture. I find proceedings at ICC are very heavy, but there are ways. I think Andrew's right. I think for one thing, defense and prosecution should be getting together and agreeing on everything they can and narrowing the issues. That would really help. But it really so much depends on the circumstances and dynamics of the particular trial. I can't really get into details about things that are happening now, but sometimes with the best will in the world, you're stuck because of other circumstances in calling the case in a particular way, which you might not have done if you were able to run it the way you really wanted to. That's very cryptic, and I'm sorry for that, but I can't say more. But yes, I mean, I think a lot of improvements can take place, and I think there's a will to improve, certainly on the part of the Office of the Prosecutor, given the independent experts review process that we were engaged in, but also on the part of the judges, and I think particularly judges like Judge Joanna Corner.
Kirsty.
Well, it's not quite on the advocacy side, but yes, I agree. The written advocacy can be overly laboured, especially when you're given 20 pages, so they take 20 pages and it could be 2.
Yeah.
But the number of witnesses who are called as well, I think that's a failure to narrow the issues, and a sort of trial by volume rather than quality, and I think there is an issue where your alternative is to sort of accept the prosecution witness statement or the opposing party's witness statement, which they've prepared, and the witnesses may well not come up through. So you're kind of forced to cross-examine them just to take the sting out. You know, that's something that perhaps you'd rather not be in that position. So that I think the parties should be cooperating a little bit more and then narrowing.
Can I offer a different perspective entirely? These are really big cases, make no bones about it. There are serious crimes with a lot of big issues connected behind the crimes, all of which have to be proved. All of which you have to prove whether there's been a systematic attack against a civilian population that was widespread. You know, you have to put the context there. You're dealing with extremely big issues that are far bigger than any national court faces. I found I've always been in trials where the judges have applied time limits to how long you can have with a witness and how long you can cross-examine for. And if it's obviously a case where it's unfair to restrict someone because it's the prosecution take 10 minutes and he's a big witness for you, then they accommodate you and give you more time. So I don't think it is the advocacy, actually. I think it is the nature of the work. So I make no apology for trying to cross-examine very difficult witnesses where the judges and no one really is totally connected. We're all from different backgrounds, cultures, experiences. We're not all on the same plane. I make no apology for trying to get the answer right in the trial. That's very, very important. And I don't believe in this expedient justice. The Kenyatta case was one where we were told for trial we would only have 16 witnesses. That suited the prosecutor. It did not suit the defense because we were taking apart the whole indictment, the evidence, and that required proving because they'd not effectively investigated the case to get the truth. So yeah, I come from a different perspective. There's another question here, which is quite an important one from Rachel Warner. Is there still a role for international justice, truth and reconciliation commissions? And the war in Ukraine is referenced. Now, what's the flavor at the moment internationally in relation to truth and reconciliation commissions, Andrew?
Yeah, I mean, I suppose having actually spent so much time in these international courts, the ad hoc tribunals, the Icc, the Icc, I sort of got converted to them, but I do actually see now, I think, the benefit of truth and reconciliation commissions, because I think oftentimes the reality is in all these courts, even though it is a combination of inquisitorial civil system, the adversarial system, predominantly it's the adversarial system that dominates in these courts. It's a battle of evidence. It's the evidence is thrown into the crucible and somehow you have to decide whether somebody's guilty or not. And I don't think it's always the best way of dealing with it. I really don't. So I'm not saying that should be so for the Ukraine, because I think the arguments there are more complex, but I certainly do see a role for truth and reconciliation commissions in certain circumstances, maybe working alongside international justice. If you look at the problems with international justice in the Ukraine, the ICC doesn't have jurisdiction over the crime of aggression. There's now talk about setting up an ad hoc court to deal with crimes over which the ICC has jurisdiction in the Ukraine. So there's no agreement at the moment. There's lots of different parties
not fighting over international justice, but sort of promoting their own interests. You know, the Ukrainians are also running domestic trials of their own. So I can see in certain situations the benefits of a non-adversarial proceeding where you're just trying to get to the truth about things as opposed to finding people guilty or innocent.
Kirsty, what's your take on it? I
think there are lots of different forms of accountability, and it's important to remember the public accountability is a sort of valid concern, and that's of course the focus of commissions of inquiry and fact-finding missions, and that there is an increasing call. I think it's been documented within the international political sphere for criminal accountability, and I think I agree that it's not always the most effective way to lead to an enduring peace.
But I just think the rawness of some of these crimes and the feelings that fester within the victims, the families who've lost people, you have to take that into account. I agree there is a role, as there was in South Africa, for truth and reconciliation commissions, but I think there is too a role for the cutting edge of the protection of international human rights, and that is prosecution and punishment of people who commit the worst atrocities. You just can't walk away from them.
Yeah. Let's answer probably what is the last question that we have time for. Is the ICC still vastly overburdened? What you're there at the moment, fresh from the corridors of the ICC.
I think James might be better placed to. So we were the only people there during COVID. So to us, it was a vastly empty building, right. Just us and security guards. But I think probably the resources are stretched very thin.
I mean, I remember saying once to the representative from a state party that the most anguishing part of my job as deputy prosecutor was trying to match resources to demand. And the ICC, in my view, has never been properly resourced. It's never been, the ship has never been righted. What I find very encouraging today, although there are criticisms about it because we're dealing with a war in Europe, what about all of the horrors that are occurring in Africa and elsewhere? But that's fine in the sense that at last states parties are realizing if the ICC is to perform what they designed it to, they have to invest in it. And so there's a huge investment, financial and in terms of secondments and everything else in relation to Ukraine. It's been prompted by what's happened in Ukraine. And I think perhaps this may be, if this kind of momentum can be continued, if it can be properly controlled, hopeful for the future. But right now, yes, I would say that the ICC is overburdened.
There are a large number of investigations, aren't there, Andrew, by the prosecutor. If you look at the map, it's sort of lit up by it.
Out of Africa now.
How many cases? Yeah. You know, globally, there's a lot.
Yeah, there are. I mean, there's a lot that, I mean, I can't remember them off the top of my head, but a lot of investigations going on. And also what James referred to earlier, these preliminary examinations where essentially the court is looking to see whether it has jurisdiction. So it does have an enormous burden upon it. But I would actually add here, having been back in the domestic system in my current job as the chief inspector at the CPS, I mean, the domestic criminal justice system in this country is overburdened.
Yeah.
You know, I'm not saying, I mean, I think that problem exists absolutely everywhere, that criminal justice systems are overburdened by the volume of work. I mean, I think what the international community has to accept with the ICC and maybe is this concept, this founding principle of complementarity, whereby there has to be more work done to ensure that the domestic jurisdictions themselves are investigating and prosecuting cases, and that the court is really one of last resort. The problem is, of course, is that many of the cases that the court is dealing with, the International Criminal Court is dealing with, have to be dealt with by the court because the domestic jurisdiction cannot deal with the investigation or the crimes. I mean, Uganda, for example, the case that James mentioned, I mean, I worked on that briefly when I was at the ICC, and that was why the case was referred by the Ugandans, because their criminal justice system just could not cope with these kinds of crimes. There were political reasons too, but you know, that's the problem. There are all of these tensions increasing the volume of work of the court.
Yeah, and the other thing is, of course, that the investigations sometimes serve as a stimulus to a country to investigate and do its justice in a proper way. And that's important. But there's a lot of pressure from a lot of people bringing cases to the ICC. They get rather swamped, I think, James, don't they? With every incident that there is, there are people promoting their cases for prosecution.
I suppose the good thing about that is that everybody invokes the ICC. It means that it's become part of the public imagination.
Yeah.
And the notion of some kind of morality or limits in war has become a very real concept out there in the world. And I think that's good. But yes, you're right. There's a lot of people coming, knocking on the door.
As Richard Goldstone said to me many years ago when the ICTY had first opened its doors, that he felt that the world was a better place because there was international courts and international justice. And I think that's something all four of us would agree upon. Right, it's now past 7:15 and we have to close the event for this evening. I'd like to thank my speakers here on behalf of the Inner Temple, Andrew Cayley, Kirsty Sutherland, James Stewart, for what I thought was a very stimulating, informative, interesting evening, and great to see some old chums and adversaries and sit on the same side of the benches as you. So thank you very much to the Inner Temple for putting on this event. And that's it. Thank you very much.
Thank you.